Hello, landlords. It's Ernie Garcia, landlord attorney, and today we're talking all about a writ of possession. What is it? How do you use it? And why do you need one? Let's get started. Well, if you're watching this video, it's probably because you heard the term writ of possession, either before you filed an eviction or possibly at the courthouse, and you want to know exactly what it is and how it works. And so today's video is all about that topic. What is the writ of possession? It is an order signed by a judge. And essentially, it is the only thing that can be used to remove a tenant who otherwise will not voluntarily vacate, to physically remove a tenant from residential or commercial rental property. Believe it or not, the judgment itself is not enough. I see landlords who come to my office and they say, I've got a judgment. How do I take it and force my tenant to leave? I'd like to show up today with a moving crew. And I tell them that's not how it works. You need to get a writ of possession. That document is the order that a judge will sign, and it essentially informs either a sheriff or a constable of the duty to remove a tenant. Now, the order itself, the writ, is an order to a sheriff or a constable who will enforce it. They'll have to post notice to the tenant by actually placing the document on the door and giving the tenant no fewer than 24 hours notice before the writ is enforced. So when can you get your writ of possession? You have to have filed an eviction lawsuit and you have to have won the case. But once the case is final, after the ability of your tenant to appeal has evaporated and the tenant hasn't appealed, then you are then eligible for a writ of possession. And you can go to the courthouse, either the justice court or if on appeal, the county court, and purchase your writ of possession. There's another time when you're eligible for a writ of possession, actually in the middle of an appeal. If a tenant has appealed and has agreed to pay rent into the court's registry but fails to pay that rent, you are eligible to get a writ of possession. It is not something that happens automatically. You would have to go to the justice court and purchase it if the justice court still has the ability to do it. I'll tell you that during an appeal, that ability goes away pretty quickly, and they send the case on appeal to the county clerk's office, and at that point, the justice court isn't going to help you. However, if you arrive on time during this window, you can seek a writ of possession at this time. If, however, the matter is on appeal and the case is with the county clerk's office or at this point the county court, and the tenant is in default, you can actually seek a writ from the county court as well, but you would have to set a motion and get a hearing and get the county court judge to issue the order allowing the writ of possession. Once that order is signed by the county court, then you can go to the clerk's office and purchase your writ of possession at that time. So along with the writ not being automatic, it's also not free. In Harris County, the fee for a writ is $130, and that's pretty true across many of the counties in the state. And so you'll want to check out the justice court in your area or the county clerk's office in your area to see what is charged for a writ of possession. If you request it by e-file, you might have some filing fees to pay through your e-file service as well. But essentially, the fee is about $130. So many landlords want to know, well, how long does it take? I understand that it's all wrapped up in 24 hours. Isn't that true? No, not exactly. It's going to take a little longer than that because of the processing of the writ itself. Remember, you go and you purchase the writ from the clerk, either the justice court clerk or the county clerk's office, and then the matter is shifted to the judge who signs the writ, and then it's delivered to the constable who reviews the writ, and then the constable goes and delivers the writ, and then usually another constable executes the writ. And so that process tends to take about 2 to 3 weeks. It doesn't seem like it should take that long, but usually does. In practice, I tend to let landlords know you can expect about 2 to 3 weeks of wait time. Might it happen sooner? Sure. But during particularly busy seasons and during the holidays, there is inevitably some delay. And so 3 weeks might become 4 weeks if you get your writ between Christmas and New Year. I mean, they're gonna sit on it for a while. Unfortunately, the timing just isn't good. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing. So we talked a little bit about who executes the writ. That would be the constable. And it's not always the same constable who delivers the writ. Where landlords get themselves in trouble is they post their own writ of possession, because you'll get a copy of it, you'll have access to it, and they'll go and they'll tape it to the door themselves and call the tenant and say, hey, I'm ushering you out of here if you're not out by sundown or whatever. That's not the way it works. The fact that you've delivered it early to your tenant doesn't mean that it's taken any effect. Everything's in the hands of the constables or the sheriffs, and so don't interfere. The last thing you want is for the tenant to, request some kind of emergency assistance to prevent you from exercising your writ of possession. So what happens after the notice has actually been delivered to your tenant by the constable? Well, typically, if a tenant stays, and that is not typical. Generally speaking, once a tenant receives this notice, they're probably going to leave. I see very few occasions where the tenants actually stay to be removed by force. Unfortunately, it does happen. And so when it does happen, the constables will coordinate with you, the landlord, to do one of the following. Some counties, and all counties have the authority to do this, and some counties still do it, where they will put a tenant's items in storage and then charge the tenant fees for that storage. In Harris County, that's no longer the case. You'll want to check with your county whether that's the case or not. In your lease, you may have a clause that allows you to store your tenant's abandoned property, which this would be at the point of a writ of execution. It would be abandoned property. The normal procedure in Harris County, if a tenant is still in possession of the premises, or if the tenant's property is still on the premises at the time that a writ of possession is executed, then the constable will contact the landlord and coordinate with the landlord for a specific time of arrival. The constable will further inform the landlord that a moving crew will be needed to go in and remove all of the personal property owned by the tenant. The landlord will also need to have access to the unit, which means either they must have a spare key or a locksmith or some way to enter and then later secure the property once the writ has been fully executed. The landlord will arrive there with the constable and that moving crew, and then will literally empty out the personal property belonging to that tenant. That property is then set there on the street side and set there for heavy trash pickup whenever it comes through the neighborhood. At that point, all of the property is considered abandoned and essentially available to the world, including the tenant. But sometimes, it's set out and nobody takes any of it. The trash comes, collects it all, and it goes to the dump. It's a very sad and unfortunate situation for a tenant to find themselves in, but it's not without sufficient and substantial notice. If you have won an eviction trial and you have questions about how to execute a writ of possession for your unit, feel free to give us a call. We do tons of these all the time. We can assist you with the process and walk you through it. We can even e-file the request for you. And so if you don't have experience with this sort of thing and you would like assistance, my contact information is here at the bottom of the screen. We welcome your questions and offer our assistance if that's something that you need help with. Until next time, though, landlords, happy leasing.